Okay, Mr. Murphy, are you going to need to speak to Mr. Rutledge?
I will not, Your Honor. We can just proceed on the record whenever the court's ready.
Okay. You can call the jail if they have a second. Mr. May.
Could we make you May, please? Yes. Thank you. Bye.
Okay, this is file 25-22275-FH People versus Lucas Allen Rutledge. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their, I'm sorry, we're here for arraignment today. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, of the People.
Matthew Murphy, appearing on behalf of Mr. Rutledge.
All right, and Mr. Rutledge, I'm sending you a request to unmute. You are Lucas Allen Rutledge, correct?
Correct.
Sorry, could you say that a little louder?
Yes.
All right, Mr. Murphy, does Mr. Rutledge wish to have the information read today?
Your Honor, word waiver, reading of the information. We acknowledge receipt of the information, witnesses, and the discovery demand by the prosecution in this matter. We ask the court to enter and continue not guilty plea at this time and to set the court or set the case for a pretrial at the court's earliest convenience.
Okay, I'll enter a not guilty plea and set a pretrial for July 9th at 8:15 a.m.
Thank you, Your Honor.
So, Mr. Rutledge, you need to log back in again on July 9th at 8:15 a.m. You'll use all the same Zoom information that you used today.
Okay.
You can go ahead and log out.
Thank you, Mr. Rutledge. I'll talk to you soon, okay?
Thank you.
Okay, Mr. Murphy, do you need to speak to Mr. Owen?
If I could just briefly, Your Honor, just be a minute.
1 second.
Thank you.
Okay, Mr. Malero, do you need to speak to Mr. May?
Yeah, I wouldn't mind if I could.
Okay. Mr. May, I'm going to put you in a breakout room with Mr. Malero in just a second.
All right, thank you.
is file 25-22208-FH People versus Daniel Jason Owen. We are here today for a rearrangement on this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure of the people.
Matthew Murphy, appearing behalf of Mr. Owen.
And does Mr. Owen wish to have the information read?
No, Your Honor, at this time, Mr. Owen will waive a reading of the information. We acknowledge receipt of said information. We've reviewed it and we understand, Mr. Owen understands the charges against him. We acknowledge receipt of the witness list and the discovery demand by the prosecution in this matter. I also want to place on the record that we received a large packet of about 300 or so pages of discovery from the prosecution recently. So I just wanted to place on the record they did receive that, and we've sent that over to Mr. Owen there at the jail, I believe, yesterday. So we just ask the court to enter and continue a not guilty plea and set a pretrial in this matter, whatever the court finds convenient. And then again, I'll talk to Mr. Owen and we'll update the court at that time.
All right, so we'll enter a not guilty plea for Mr. Owen. We'll set this for a pretrial conference on July 2nd at 8:15 a.m. Anything else we need to address with this case today?
Nothing from the defense, Your Honor. Thank you.
Nothing on behalf of the people.
Okay, Mr. Owen, you can let the officer with you know that you're done with court for today.
Thank you, Your Honor.
Thank you, Mr. Owen. I'll see you soon, okay?
Yep, sounds good.
And Mr. Murphy, I have Mr. Dillenbeck. Do you need to speak to Mr. Dillenbeck?
I will, Your Honor. I will need to speak with him.
Okay. Mr. Dillenbeck, I'm going to put you in a breakout room with Mr. Murphy.
All right, thank you, Your Honor.
I'll be back, Pastor Josh. I'll go back in my room.
Okay, Mr. Malero, are you ready to proceed with Mr. May?
Could we have Landon Thompson?
Yes,
Thank you.
yes, I am, Your Honor. Yes,
Okay,
I am.
this is file 25-22194-FH and 25-22216-FH. People versus Matthew Ryan May. We are here today for pretrial conferences in both of those cases. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
Phoebe McClure of the people.
Salvatore Malero on behalf of Matthew May.
Okay, and Mr. Malero, where do we stand with Mr. May's cases today?
Yeah, we're going to ask to adjourn the matter. For the basis is one, I'm going to ask to have Mr. May screened for recovery court. The second reason is that there's a matter in Jackson that I'm trying to determine if he has counsel and see if we can resolve all the matters at one time.
Okay, Ms. McClure, anything we need to address from the people's side?
Yes, Your Honor, just that the one offense is an assaultive crime that I think would be of the nature to preclude him from recovery court.
Well, I mean, that's up to recovery court to make that determination, is it not?
Yeah, I don't know all the rules in recovery court, whether that precludes or not, but if you want to have a screen, that's fine by me. So let's go with July 2nd at 8:15.
Thank you, Your Honor.
Mr. Malera, would you prepare that stipulation in order for the adjournment?
I will gladly do so for you, Your Honor.
All right, so Mr. May, you can let them know that you are all set with court for today.
All right, thank you, Your Honor.
Thank you, Judge.
What's the next pretrial, Judge? I'm sorry.
July 2nd. All right, Mr. Valero, you need to speak to Mr. Thompson.
Yes.
Okay, give me just a second here. Okay, this is file 24-22094-FH, 24-22095-FH, and 25-22197-FH. All of the cases are set for pretrial this morning. 24 cases both have a pending contempt of court tagging along with those. So first, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, may I have the people?
Matthew Murphy, appearing on behalf of Mr. Dillenbeck.
Right, and Mr. Murphy, where do we stand with Mr. Dillenbeck's cases today?
Your Honor, we have a plea agreement worked out with these cases in front of Your Honor. There is another open warrant for a pending case down in district court that's not involved in this plea. I informed Mr. Dillenbeck about that just now. He wasn't aware of that. So he's going to take care of that separately. Again, that's not involved in this plea. But in regards to this matter, or these matters, I'm going to try to, we signed and sent over the plea agreements. I forgot, I'm not sure what the court needs before the plea is entered or after this in regards to the advice of rights. But Mr. Dillenbeck is in Muskegon, so we can try to have him, sign, or I can sign on his behalf any advice of rights or anything that's required. So I do apologize about that. But if the court will let me continue, the plea agreement, as I understand it, again, I believe that we signed the papers. It's that in file 2422094, Mr. Dillenbeck will plead guilty to one count, receiving concealing, no second offense notice, no habitual offender notice on that. Dismiss any remaining counts on that file. On file 2422095, Mr. Dillenbeck will plead to possession of methamphetamine, no habitual offender status on that, nor no second offense status if there was one. And then on file 2522197, he will plead guilty to one count, breaking any with intent, no habituals, no second offender status or anything on that, and dismiss remaining counts. And there was restitution of $735, I believe. I forgot which file that was on. That was the 9794. But Mr. Dillenbeck, I'm sorry.
No, I was gonna say that is on the 9-7 file. On the 9-4 file, I don't believe there's any restitution, or on the
Okay.
9-5 file. Obviously.
All right, thank you. So at this time, Mr. Dillenbeck does wish to accept that offer and plead guilty as previously stated.
Okay. Mr. Dillenbeck, I placed the advice of rights form in the chat. Are you able to open that and look at it?
I will try, Your Honor. I can see it, but I don't know how to sign it electronically.
Okay. I don't need you to sign it right now. Just take whatever time you need to read through that and just let me know when you're done.
Okay, thank you. Okay, Your Honor, I'm ready.
All right. Could you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
I do, Your Honor.
And you are Ryan James Dillenbeck.
Yes, Your Honor.
Mr. Dillenbeck, as we discussed, I put the PDF file with the advice of rights form in the chat. You were able to open that, is that correct?
Yes, Your Honor.
And you have been able to read that entire form, is that correct?
Yes, Your Honor.
And when we're done here today, are you willing to make arrangements with Mr. Murphy to print a hard copy and sign that form in return?
Yes, Your Honor.
Okay. You have heard the statement of your attorney and the prosecuting attorneys that your intention in file 24-22094-FH to plead guilty to count 1, receiving and concealing stolen property.
Yes, Your Honor.
You understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine or 3 times the value of the motor vehicle, whichever was greater.
Yes, Your Honor.
Is it also your intention to plead guilty in file 24-22095-FH to count 1, possession of methamphetamine?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes, Your Honor.
Is it also your intention to plead guilty in file 25-22197-FH to count 1, breaking and entering a building with intent?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison?
Yes, Your Honor.
Are you satisfied with Mr. Murphy and the advice that he's given?
I am, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Dillenbeck?
Yes, Your Honor.
If a guilty plea is accepted, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Dillenbeck, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor. Thank you.
And you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead in file 24-22094-FH to the charge that on or about December 15, 2024, in the city of Adrian, County, Lenawee, State of Michigan, that you did commit the offense of receiving and concealing stolen property, a motor vehicle?
Guilty, Your Honor.
And how do you wish to plead to the charge that on or about in file 24-22095-FH, the charge on or about December 16, 2024 in the city of Adrian County, Illinois, state of Michigan. You did commit the offense of possession of methamphetamine.
Guilty, Your Honor.
And in file 25-22197-FH, how do you wish to plead to the charge that on or about January 12th, 2025 in Palmyra Township, Lenawee County, Michigan, that you did commit the offense of breaking and entering a building with intent?
Guilty, Your Honor.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that the pleas were given as a result of threats or promises that were disclosed to court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements to induce, other than the plea bargain, to induce Mr. Dillenbeck to plead guilty today?
No, Your Honor.
None, Your Honor.
Mr. Dillenbeck, has your attorney promised you any particular sentence or estimated what your sentence would be?
Other than the plea bargain, no, Your Honor.
Okay. If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Murphy, do you want to cover the factual basis?
Yes, Your Honor. I'll try to cover the factual basis. So let's start with file 2422094FH. Mr. Dillenbeck, can you hear me okay?
Yes, sir.
All right. Now, were you indeed in the city of Adrian County, Illinois, state of Michigan on or about December 15, 2024?
Yes.
And on or about that date and time, did you indeed try to conceal or have in your possession a motor vehicle, a Ford, that you knew or reasonably should have known that it was stolen?
Yes.
And do you know who that vehicle belonged to?
Not off the top of my head, not the real owner.
Okay.
Would you agree that it's Jason Fleener?
If that's what you guys say, yes. I'm sorry, I just don't know for sure the name.
You would
If that's
have
what the
no.
investigation revealed, you wouldn't object to that.
I'm sorry, what was that?
If that is what the investigation revealed, you wouldn't object to that?
No, ma'am.
Okay.
And you would agree then that you had no right to possess that vehicle, that it was obviously his property?
Yes.
Your Honor, I'm satisfied with the factual basis. I don't know if Ms. McClure was or not.
I'm satisfied, Your Honor.
Okay, Mr. Murphy, you can move on to the next one.
Okay, file 22095FH. I'm sorry, I got to pull up the. So, Mr. Dillenbeck, were you indeed, again, in the city of Adrian County, Illinois, state of Michigan, on or about December 16, 2024?
Yes.
And on that day and time, did you indeed have in your possession a substance of methamphetamine?
Yes.
And did you know that it was methamphetamine when you were possessing it?
Yeah.
And did you believe you had any legal right to possess that methamphetamine?
No, sir.
And did you possess it for your own personal use?
Yes, sir.
Your Honor, I'm satisfied with the factual basis on that file.
My only question on this one, because it does pertain to guidelines, so for probation's benefit or the PSI benefit, was this the possession of methamphetamine, was that located on you at the same time they were investigating that stolen truck that you had just pled to?
Yes.
Okay. I'm satisfied with the factual basis.
All right, Mr. Murphy, you can continue.
Okay, now on file 2522197FH. Mr. Dillenbeck, were you again in Palmyra Township, County of Lenawee, State of Michigan, on or about January 12th, 2025?
Yes.
Now that day and time, did you go on to a property, an 8687 East US 223?
Yes.
And did you try to enter or indeed enter a building with the intent to commit a larceny in that building?
Yes, sir.
Did you recall taking anything out of that building?
The Jeep.
And that would be the 2003 Jeep that was also involved in this incident?
Yes.
Okay, and would you agree that that Jeep belonged to a Joseph William Schrader?
If that's what the investigation inquired, yes.
Your Honor, I'm satisfied with the factual basis on this.
Satisfied, Your Honor.
Okay, has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Murphy?
It has, Your Honor, thank you.
I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Dillenbeck has had full knowledge of his rights and he's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for July 18th at 8:15 a.m. Mr. Dillenbeck, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Okay. Thank you, Your Honor.
Okay, and so I am also going to put you in a breakout session with Mr. Stevenson from the probation department. He's going to tell you when you need to report and give you some additional information.
Okay. Thank you, Your Honor.
Should I be a part of that, Your Honor?
Thank you, Matt.
I'm sorry, Mr. Murphy, you said you wanted to be part of that.
If I could, please, Your Honor.
Just
The
give me
only-
1 second.
Sorry, Judge. The only thing else I wanted to say to Mr. Dillenbeck and Mr. Murphy is that it appears he still needs to be arraigned on that new file in district court.
Yeah.
Yes, ma'am.
Okay, this is file 23-21521-FH, People versus Landon Thompson. We are here today for a pretrial conference in this case. We're here related to an alleged contempt of court for failure to appear at sentencing. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
B.B. McClure, map the people.
Salvatore Malero on behalf of Landon Thompson.
I'm sorry, our recording system froze, so we need to stop. Oh, all right, it's okay. All right, so we are here. Mr. Thompson had pled guilty. A sentencing date was set, didn't appear at sentencing, and so a warrant was issued. He'd been picked up on that warrant and arraigned the other day and set for a hearing today. I believe at the arraignment on the warrant, I set sentencing for July 17th at 8:15. We do not yet have a pre-sentence investigation report completed, but I do, I think that there should be sufficient time between now and July 17th. That's complies with the requirements we're supposed to give the probation office. So, Mr. Malero, is there anything that you want to address with the case today? I'm not picking up your audio.
How about now?
Okay, now we can hear you.
All right. So Judge, the note I have was that sentencing was scheduled for July 7th. Is that not this?
I was going from memory, so you're probably right. Let me look it up and make sure.
Well, it's not my memory, it's somebody else's.
Yeah, we have it, looks like in the register of actions, we have it set for July 17th.
Okay, that's fine. I just saw that note from someone else. Judge, I was going to ask to adjourn this a week for several reasons. One, to see if there's going to be an absconding charge filed. Two, Mr. Landon informs me that he has employment in Napoleon, Ohio, and I wanted to verify that. Three, there was supposed to be a recovery court component to the underlying matter. And that if he's living in Ohio, that's not gonna happen. He also has some misdemeanors that he informs me he received a PR bond on yesterday, but I cannot verify that. So that was the reason I'd asked to adjourn this a week. I'd hate to have him lose employment. But I understand that there's a sentencing date set out in the future. So, and I understand, he's been gone a year. It's also my understanding that when he was arrested on the outstanding warrant, he does not expect any additional charges out of that arrest, which I think at least something positive. So that's the reason I would be asking to adjourn it a week.
Okay, Ms. McClure, anything that people want to address?
No, Judge, we would just defer to the court.
All right. So I'm gonna leave the sentencing date set on the 17th, July 17th at 8:15. Mr. Stevenson, just so you're aware, this is Landon Thompson that we're talking about right now. He was picked up on a warrant for a failure to appear at sentencing. A pre-sentence investigation has not yet been completed. It looks like Ms. Teskey is the agent assigned to him. But we have sentencing set now for July 17th.
Okay, I'll pass that message on.
Okay, and so I'll adjourn a pretrial on the contempt to next week is June 18th at 8:15.
Did you say June 18th?
Oh, I'm sorry. Yeah, I said June 18th. I'm not here next week on the 11th,
Okay, that's fine.
so I can't do that.
The 18th is fine, Judge.
Okay. All right, so June 18th at 8:15 a.m.
Okay, Thank you,
Mr.
Judge.
Thompson, you can let the officer with you know that you're done with court for today.
I appreciate it.
Thank you, Judge.
And I think I have Mr. Outley here, Mr. Malero.
Oh, yeah, I see him.
Just waiting for him to get his audio connected. All right, Mr. Outley, can you hear me?
Yes, I hear you now. I'm sorry, my front camera a little messed up. I'm sorry about that. I was trying to turn it on, but it's not working.
All right. Mr. Malero, do you need to speak to Mr. Outley?
Yeah, I think I do.
Okay, 1 second.
Thank you, Judge.
call Katie Mott's office and see if Okay. This is file 23-21432-FH People versus Harold Eugene Outley. We are here today for a pretrial conference in this case and proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
E.B. McClure, may I have people?
Salvatore Malero on behalf of Harold Outley.
All right, and Mr. Malero, where do we stand with Mr. Outley's case today?
Your Honor, I believe we have reached an agreement by which Mr. Outley will be pleading guilty to count one, false pretenses of 1,000 or more, but under 20,000, and count two of using an illegal use of a financial transaction device. The further would be an agreement that there'd be no additional jail time. Further, there'd be an agreement that there's restitution in the amount of $2,431 that Mr. Outley would be required to pay as a condition of his this plea. And I believe there's no further condition or no further terms of the plea agreement.
Great. Ms. McClure, is that a complete and accurate statement of the plea?
Yes, it is.
All right, Mr. Outley, I'll need you to raise your right hand. Let me know when you have it raised, please.
It's raised.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Harold Eugene Outley?
Yes.
Mr. Outley, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count one, false pretenses $1,000 or more, but less than $20,000?
Yes.
Is it? Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and/or a fine that is the greater of $10,000 or 3 times the value of the money or property involved?
Yes.
Is it also your intention to plead guilty today to count 2, illegal sale or use of a financial transaction device?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and/or a fine of $5,000?
Yes.
Are you satisfied with Mr. Malero and the advice that he's given you?
Yes.
Either the prosecutor, defense attorney, or defendant have discussed possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Mr. Malero?
That is correct, Your Honor.
Is that also your understanding, Mr. Outley?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. You do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Outley, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about March 28, 2023 in Madison Township, Lenawee County, Michigan, that you did commit the offense of false pretenses $1,000 or more, but less than $20,000?
Guilty.
And how do you plead to the charge that on or about March 28, 2023 in Madison Township, Lenawee County, State of Michigan, that you did commit the offense of illegal sale or use of a financial transaction device?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that the pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes.
Prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Outley to plead guilty today?
No, Your Honor.
No, Judge.
Mr. Outley, other than as we've discussed it on the record here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
Mr. Malero, do you want to cover the factual basis?
Yes, I do, Judge. So, Mr. Outley, is it true that on or about March 28th of 2023 that you were in the Lenawee County, Madison Township, state
Yes.
of Michigan? In the state of Michigan?
Yes.
And that location was also known as 2768 East Maumee Street, also known as the Lightning Quick Gas Convenience Store.
Yes.
Okay, and while in that store, did you use credit cards for which you did not have authorization to use to purchase $2,431.80 in lottery tickets?
Yes.
And you knew those are credit, you didn't have authorization to use those credit cards?
Yes.
And you knew that you were using false pretenses in excess of $1,000 but less than 20 to make those purchases?
Yes.
And it was your intent to defraud or cheat either Lightning Quick or the credit card agency or the person that had those credit cards. Is that true?
Yes.
Is the state and the court satisfied?
Just to be clear, Mr. Owley, you actually you didn't have the physical cards, but you had the credit card numbers on your phone, and you had to, use or represent those credit card numbers to make those purchases.
Can you say that again? I'm sorry.
To be clear, you didn't have the physical credit cards, but you had numbers on your phone, credit card numbers on your phone, and you had to make a representation that those were yours at the time you made these purchases.
Yes.
And was the total, maybe you already said it, but was the total of that $2,431?
You said, was that the total?
Yes.
Honestly, I'm not sure, but I just remember making a purchase. I don't remember the total.
Mr. Malaro, would you stipulate that the total was of 9 transactions was $2,431?
Okay. Yeah. Yeah.
Stipulate the $2,431.
Not picking up your audio, Mr. Malero.
$2,431.80.
Okay.
I was just asking for stipulation. I believe then it's so stipulated.
Yes.
Okay.
All right. Has the
People
court
on our
complied with
side.
I'm sorry.
That's okay.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Malero?
Yes, I believe the court had.
I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Outley has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as has been stated on the record today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for July 18th at 8:15 a.m.
You're
He's,
I'm not going to be here on the 18th. Well, I guess it doesn't matter. Someone can cover for me.
Okay. So July 18th at 8:15 a.m., Mr. Outley, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
okay.
I'm going to put you in a breakout session with Mr. Stevenson from the probation department so he can collect some information from you and give you some instructions on what's going to happen next.
Okay.
Thank you, Judge.
Thank you, Mr. Malero. Okay, so Paul Stevens. This is file 24-21943-FH, People versus Patrick Allen Stevens. We are here today for a pretrial conference in this case and proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
A.B. McClure, map the people.
Salvatore Malero on behalf of Patrick Stevens.
All right, we do not have Mr. Stevens here. Mr. Malero, do you know whether he is still incarcerated in Eaton County?
So, Judge, my last note was he was at the Eaton County Jail. And I don't know if he's still there or where he's at.
Okay, I should have waited for Mr. Stevenson. I think he was the one that had information on that.
I can wait.
Let me pass this for a minute and call the Tindle case. So this is file 25-22234-FH and 25-22149-FH, People versus Terrence Tindle. We are here today for a pretrial conference in this case and proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Dumont.
Katarina Dumont for Mr. Tindle.
B.B.
I'm
McClure,
sorry,
map the people.
Just trying to mix it up a little bit once in a while. Okay, so Mr. Tindle is not present in the Zoom session or logged into, or here in the courtroom. Ms. Dumont, do you know anything about where he is today?
Your Honor, the information that I have from Mr. Coast is that he was released to patient rehab, was there for 5 days, and then left. So I believe there's a $25,000 bond or a $25,000 warrant issued already. But other than that information, I don't have anything else.
Ms. McClure, anything that we need to address from the people's side?
No, nothing to add.
Okay. I did, as I recall, have a issue a warrant based on Mr. Tindle leaving the treatment facility, and he has also failed to appear here today. And so I'm going to issue another warrant for the failure to appear. I'll set bond on that bench warrant in the amount of $10,000 cash assured.
Thank you.
Okay, thank you, Ms. Dumont.
Thank you.
Okay, and then we can go back to the Stevens case. So back on the record in file 24-21943-FH, People versus Patrick Allen Stevens. Mr. Stevenson is back on the breakout session now. So Mr. Stevenson, we were wondering, did you happen to have any additional information on whether Mr. Stevens is still at the Eaton County Jail?
Yes, I did check this morning and he's still in jail in Eaton County. So if we could, I'd like to push this back another 60 or 90 days.
Okay. Mr. Malero, do you have any issue with that?
I get, this is for his failure to report, but didn't he just kind of like, are we just doing this just to make sure we keep track of them, or what are we doing?
Yes. From my point of view, I'm concerned that he'll get out. We won't see him again. He never reported when he was placed on probation.
Well, I think didn't that because they took him off to jail somewhere?
But I wasn't able to make contact with him. I'm concerned
Okay.
that he won't report.
I can drive you up there if you want.
Thank you.
I based on Mr. Stevenson's comments, Ron, I have no objections.
Okay. So I'll set this over to August 6th at 8:15 a.m.
And Judge, if he does get out and makes contact with me, I would dismiss the show cause.
Okay.
Thank you, Your Honor. Thank you, Mr. Stevenson, for your kind words.
Thank you.
Okay, I think that is all of the criminal docket this morning.
Thank you, Judge.
Thank you very much. Have